Good afternoon, everybody. For those that don't know me, my name is Tom Munns, and I'm with my esteemed colleague Ron Nielsen, and it's great to have you here, Ron. Thank you for joining me again today.
Absolutely. Thanks for inviting me once again for another one of these videos. They've been very helpful, I've been hearing. So
Well,
feedback's been great.
if it wasn't about you, then man, I wouldn't be here because this is a really great topic. So, for those that don't know, you should because this is the sixth video in the series, and we would encourage you to start from the introduction so you have a better understanding of what's going on with the book. But Ron is the author of The History of Federal Lands in the United States and the Violence of Faction. If you're interested in about the book, you can contact him on his website. The link will be in the description box of this video. The link to buy the book will also be there. And the link to the playlist for all the videos will be there as well. So you don't have to try to scramble through Rumble to try to figure out where everything is. As we typically do, I'm going to start off with a review of what we talked about in video number 5. And then we'll move right into video 6, which is this video that we're talking about right now. So Ron, it seemed like we were never going to get out of the first 2 pages. We started off in on I think page 17. Chapter 2 was the Louisiana Purchase, and we were talking about the constitutional gamble. It seems like no history class was ever talking about that. So the history that you gave us about the Louisiana Purchase was great to be able to lay that foundation for the following chapters and the subsequent chapters after that. We talked a little bit about policy ownership versus disposal. We talked about factions. We talked about Federalist 10, Federalist 46, and Federalist 47 for those of you that want evidence. We talked about the necessary and proper clause. We entered into the vassal state arrangement. And then just before we finished up, we talked about the military reports and whether the Constitution follows the flag. So as we begin, I wanted to basically ask Ron if he had any thoughts before we proceed. But we're going to end up start first talking about if the Constitution was applicable to the territory. So welcome, Ron, man. It's good to see you.
Yeah, it's
All
good to be
yours.
seen. It's good to see you. I know you're going on vacation soon,
I am
so
Monday.
you're going to take a break for a bit.
Yes, sir.
Okay, so to launch into this video is going to be hard. All right, and not so much that it's going to be hard to understand. I think we can do it in a way that's understandable, but it's going to be hard in that we have to get into some subject matter that hasn't been gotten into before, as far as I know, and it's just going to be tough. So I want to do a screen share, and I want to present this as sort of the opening barrage, as it were. And I just want to begin talking about this. Let me explain what this is to everybody. All right, so can you see it, Tom?
Yes, sir. Yes,
Okay.
sir.
Okay, this is entitled Power of Congress over the Territories. This is out of a constitutional encyclopedia. These constitutional encyclopedias were drafted, they were created by the United States government printing office for members of Congress, so that members of Congress have a legislative tool at their disposal when creating legislation, so they can compare it to this to figure out whether or not there are pieces of the legislation that may or may not be constitutional, right? So this is a resource for members of Congress in 1952. Is what this is. This is out of the Article 4, Section 3, Clause 2 portion of the encyclopedia. And I'm going to read it to you. And if you can see the screen, you can see all the case law citations underneath there. This is where I began my 13-year investigation into the matter. Okay. Power of Congress over the territories. In the territories, Congress has the entire dominion and sovereignty, national and local, and has full legislative power over all subjects upon which a state legislature might act. Let's stop right there. What does that mean, do you think?
Means they have total jurisdiction to decide what they want to do when it
What
comes to
kind
federal
of
lands.
jurisdiction? They only have two.
Exclusive.
Which one? There you
Exclusive.
go. That's what they're talking about. They don't use the word, but that's what it means. Let's go over it again. Let's just look at the words entire dominion and sovereignty, national, local, and has full legislative power. That term, that term is Article 1, Section 8, Clause 17. That means if it's territorial, as far as Congress's opinion, they can apply exclusive jurisdiction. That's what this says. Let's go further. Congress may legislate directly with respect to the local affairs of a territory, or it may transfer that function to a legislature elected by the citizens thereof. Let's stop there. What does that mean?
I don't know. I was writing notes. Sorry. You could tell me what it means. Sorry.
So Congress may legislate directly. That is a vassal state arrangement. It may legislate directly.
It's a vassal
Or
state arrangement in that it's saying that it is taking its superior position over the inferior position of the states.
right, it's saying we're the dominant power and we're going to
Right.
legislate directly for that area, or we'll just go ahead and create a legislature. Now we're talking about an organic act that creates a territorial legislature. Let's read this again. It may legislate directly with respect to the local affairs of a territory, or it may transfer that function to a legislature elected by the citizens thereof. That's the Northwest Ordinance. That's what that is. Which will then be invested with all the legislative power except as limited by the Constitution of the United States and acts of Congress. What does that mean?
So they're basically saying that under the vassal state arrangement, we are going to establish some sort of, gosh, I just had it off the tip of my tongue. The other jurisdiction, not cooperative,
Exclusive?
but the other one. No, the other one. What is the other?
Proprietary? Oh,
No,
concurrent.
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 Right. So they're giving they're making you believe by what they read is that through the exclusive jurisdiction that they have, they are going to create some kind of concurrent jurisdiction. Thank you.
Right. So you're right.
I am.
When you
This
look
is
at this,
great.
you're right. When you look at this, they're saying here, the writers who wrote this, and these are constitutional attorneys, that were working with the United States Printing Office, and these people were mandated by a resolution of Congress to put this together. Okay, and they're saying Congress can decide whether or not to apply exclusive power or concurrent power. That's what it's saying here. It could either legislate directly
Mhm.
or in now it's talking about territorial legislatures, right? But the idea is it can either split off its power and share it with the territorial legislature, or it can just do it directly.
Right. Got it.
Okay. In 1886, Congress prohibited the enactment by territorial legislatures of local special laws and enumerated subjects. We can just gloss over that. That is actually written in the Idaho State Constitution, that exact thing right there. Exactly. Almost word for word.
But does
The
that statement?
Constitution.
Okay, go ahead.
Go ahead. Go ahead. Remember, you and I had a conversation about this once.
Right, but I'm assuming that it says in the next statement, it basically said, yeah, even though we could, we'd rather maintain exclusive jurisdiction, but I
Well,
could be
yeah.
wrong.
So
Keep going on.
right. So well, it basically is saying here is Congress gets to choose.
You're right.
Is what it's saying.
Okay.
All right. The next thing I'm going to read. This is where things start getting a little like what? The constitutional guarantee of private rights are applicable in territories which have been made a part of the United States by congressional action. Stop. We talked about this in the last video. And where the Constitution follows the flag or doesn't follow the flag. And it's saying here the Constitutional guarantee of private rights are applicable in territories which have been made a part of the United States by congressional action. It doesn't tell you what that means, what that says, but we go on a little bit further and we say, but not to unincorporated territories. Oh, so if we go to Downs versus Bidwell, which is in the footnotes down here in the citations, and you read that case, it talks about incorporation, what it
So,
means.
so wait a sec. So this is probably going to confuse people like it did with me. So, and we need to have a firm grasp of
Yes.
Oh gosh, I'm off my charts today. What the guarantee of private rights uh, incorporated and unincorporated actually is, because I still am still a little bit fuzzy on this, because there's several things wrong with this. One of them is that the constitutional guarantee of private rights are applicable in the territories, um, which are part of the United States. So we would have to question what that is by congressional action. That's another
Right,
problem, because if it's not even
right,
articulated in the congressional action, then you could
right.
say that those rights don't exist at all.
So when you go to the Downs versus Bidwell case, you go, okay, well, what constitutes by congressional action? That's what that was my question. Well, what constitutes congressional action, and was there for the domestic territories? So when I get into this, what I find is that Congress would have had to incorporate the territories domestically in some manner, either an admission act or some separate piece of legislation that would have had to use the term incorporated. And after a 14-year engagement now, I have not found a single piece of legislation that incorporated the domestic territories.
So one could conclude, if that everything is seen as unincorporated, then there is no guarantee of private rights at all.
So then I said, okay, this can't be true. This cannot be. So let's do this. Let's see if we can find anywhere in the United States, anywhere in the agencies where maybe they had in their guidance documents that all of the domestic
Ron, can you do me
territories.
a favor?
Yeah.
Sorry, can you do me a favor? On the lower right-hand part of your screen, there's a plus and a minus to expand the
Yes.
can you do hit that a little bit, see if it gives us a better view? Okay, good. All right. Will
Is
you be
that
able to
better?
can you scroll that up and down if you have to? Okay, good. Thank you.
Yeah,
Continue.
absolutely. Okay, so let's get about right. Let's get about right there. Okay, where was I? Oh, the constitutional guarantee. So when we were looking at this, we were trying to figure out, okay, had Congress created some sort of legislation that incorporated the areas, the domestic territories? So we're talking about all of the land that the government owns in the United States, all of it. All right. So we thought, okay, we couldn't find in the case law where they addressed it directly. That's all the case law down here, so anybody can see that. We couldn't find in the case law where it the Downs versus Bidwell case came close. It was really talking about the exclusive power and how it was being used by Congress, and they were having a hard time with it. They didn't want to accept it. So we went through the Department of Interior documents. We found that in their guidance document, in their internal Department of the Interior guidance documents, which is they're the head of the Department of the Interior is the head of the land program. They're the top. All of the other agencies that are land management agencies route through the Department of the Interior. Now they have a measure of independence for sure. So that's not what we're talking about here is their level of independence. We're talking about the hierarchical structure. It routes through the Department of the Interior. So we got a hold of their guidance documents. Guess what we found? From 1952 on, and this is just what we can verify, from 1952 to 2013, the Department of the Interior's internal guidance document specifically stated that all the territories in the United States domestic were under exclusive jurisdiction.
Wow.
So
And
we
so that
know,
that
go ahead.
that the guaranteed private rights are not guaranteed under what you just said.
That's right. As far as we could tell, the way that the lands were being classified, and this showed up in the inventory report. There were two inventories done by the United States government. There was a 1952 and a 1963 or something like that. Land inventory, a full blown inventory of the lands done by the executive branch.
So can I throw a monkey wrench in this thing just for a minute? Because
Go away.
sometimes people get a little bit lazy-eyed, so you got to kind of shock the system every once in a while, and I don't have ice water.
Right.
So let's just say, gosh, Ron, I've got my Second Amendment. I'm out there just I'm enjoying my Second Amendment, right? And I got my Don't Tread on Me shirt on, and I'm on federal land and I'm fishing, and all of a sudden they're giving me heat about why I'm carrying a firearm. Is that what you're referring to?
Yeah, there are a lot of instances.
And I didn't mean to open up a can of worms, but that's the kind of instance that we're talking about, right?
Yeah,
You think that
right.
we're
So
exercising a constitutional right, if you will, but yet the right of that is not guaranteed on unincorporated territories, which is what we're dealing with. Okay,
right.
good.
It
All right.
appears that's what we're dealing with are unincorporated territories that have not been made part of the United States. And because of that, the applicability of private rights is in question. And you see this in Rasmussen. So let's go down here. You see Rasmussen down at the bottom.
Mm-hmm.
Rasmussen versus United States, 197 U.S. 516, 1905. That's
Mm-hmm.
4 years after the Bidwell decision. So they kind of had an idea what they were doing at this point. So when Rasmussen came up, I'm going to read to you this is what happened in Rasmussen. The constitutional guarantee of private rights are applicable in territories which have been made a part of the United States by congressional action, but not to unincorporated territories. Alaska is of the former description. What is former in that previous antecedent? What is former? Can you point it out?
The former description, which was the incorporated. It was incorporated territory
That's right. I'll read this
because
sentence is talking about.
the former was the incorporation, the latter was the unincorporation, right?
That's right.
Okay,
So that means Alaska was incorporated.
right.
So if you go down and you read the Rasmussen decision, that's exactly right. So the question I had was, well, wait a minute. Why bring up Alaska when they could easily use the domestic United States as their selling point here? And they don't. Why Alaska? Why would you use Alaska?
That
It's a sleight of hand going on here. They want you to think, well, obviously the domestic territories are incorporated. We want to know about the outside of the United States.
Oh,
Oh,
I see
Alaska's
what's happening.
incorporated. You
Right,
see what's going on here?
right. I do. I do.
They're playing on your rationality in your mind. Whoever wrote this is playing on your rationale because you're automatically going to assume that the domestic territories were incorporated.
Okay, I got to ask you something else. It just came into
Go
my
ahead.
mind before it goes away. So Alaska is not one of the is not one of the
No,
contiguous in the United States.
no.
So does that make it one of the what do you call the insular jurisdiction or
Yes,
falling on it does. Okay. All
yes,
right,
it
good.
makes it insular.
I'm so proud of myself.
Yeah.
I feel like I'm getting it.
Hawaii is
Okay, good.
insular.
So are
Yeah.
they under, so if these insular cases, there is a difference, and of course it goes into it later in the book, and maybe you don't want to go through it now, but there is a difference in how the feds actually view the contiguous United States and the insular cases. Is that right?
Yes.
Okay.
All of the police power of the federal government understands. Well, the guys out in the field they don't understand this very well, but the people who run the administrative agencies are aware of this situation.
Oh. Well, that's great. We've empowered in these agencies to know more than we do. That's fantastic.
While the status of Hawaii appears doubtful, meaning that it was doubtful when this was written in 52 that Hawaii was incorporated.
And I'm from there, so I should remember when they were admitted into the Union. Was it 57? I
Uh,
think it was.
yeah, I think so. Yeah,
Anyway, it
I
doesn't
think
matter.
that's about right.
Okay. I just
Yeah, it
wondered
was
if
in the
that had any
50s.
relevance.
It was after this. So this is 52 and it came in the 50s. So it was about 56, 57, something like that. Yeah, you're right.
Okay.
So Hawaii wasn't. So this brought up a lot of things to my mind. So let's just go on a little bit here. We're going to tie a lot of things together here. All right. Congress may establish or may authorize the territorial legislature to create legislative courts whose
Legis
jurisdiction is derived from statutes enacted pursuant to this section
Article 1.
rather than from Article 4.
There it is, man. Those are the article what those are the legislative courts, the
Article 1
administrative
courts.
courts.
That's right.
Oh my gosh.
Wait, it gets better. Such courts may
Wow.
exercise admiralty jurisdiction despite the fact that such jurisdiction may be exercised in the states only by constitutional courts.
We were studying that 15 years ago.
Uh-huh. When
Oh my gosh.
when
Article
MJ
1.
had
Wow. This is crazy,
yeah,
man. Okay.
yeah. This is a government approved document. They paid for it. They paid for the guy to put this together. They're the ones that passed the joint resolution to have this done out of the government printing office, and the best constitutional minds in the United States put this together.
So is it fair to say then, follow me, you guys, just eliminate me just for a minute. I'm going to put on my tin hat, right? And I'm going to pretend I'm one of those sovereign citizens just for a minute, right? And I'm going to say that when you go into the courts, there's the gold fringe on the flag, even though I think it's like clear in the United States manual, but we're not paying attention to that, or it's not in what USC Title IV. Forget about that. But Ron, when we were talking about this, we were talking about when you enter into and forgive me if I'm taking off in the wrong way, but when you go into a court, those are those are if I understand, were military courts, right? And the Admiralty's jurisdiction part of that was when you entered into the area where the attorneys and the prosecutor and all that was, you were actually entering into the galley. So all of these are all what do you call it terms? They're all, well, Admiralty terms, but they're all terms of boats.
Right.
Am I off target on this?
No, you're not. So
Oh my gosh.
this situation gets really muddy. The water's really muddy here, and I use that sort of as a pun here because we got to get into the water issue a little bit.
No, I knew
Because
that was coming.
if it's Admiralty jurisdiction, they have to somehow attach it to water because Admiralty is attached to water,
Hmm.
right?
Hmm.
Now, the Admiralty jurisdiction is just a constitutional jurisdiction. It's an actual constitutional jurisdiction, but it doesn't make them it doesn't make them constitutional courts. It's just stating that the jurisdiction is an Admiralty one. Well, what does that mean? That means it's military.
Hmm.
That's what it means. It means it's a military jurisdiction. The United States government doesn't have an Admiralty jurisdiction that's non-military because the Constitution allows for a standing navy. All the United States military apparatus, as we've talked about a little bit, is territorial. That's an exclusive jurisdiction. That's a military jurisdiction. And here's that Admiralty jurisdiction applicable inland in Article 1 courts associated with the United States government's land program.
And of course, we had a standing army during the land program under Arthur Sinclair.
That's right.
Well, I have one question. Can I do that without causing you to
Yeah,
forget?
please go ahead.
Okay, good. So I noticed when we talk about Article 1 courts and we talk about Article 3 courts, I clearly see the Article 1, which is a great connection, by the way. But where I'm confused is it says something rather than Article 4. Wouldn't that? But are there courts in Article 4?
Article 4 is a territorial jurisdiction.
Okay. Now this would be, so now I guess now that we're being specific here, we should ask what Article 4 is. Is that Article 4 of our Constitution?
Yeah, Article 4
Okay.
of the Constitution.
Okay. All right. All right. So yeah, okay. I'm still gonna have to wrap my head around that because I got the Article 1 thing with the legislative courts, and then I got the
Here's
Article
what
3
that
right
means.
from the judiciary courts.
Here's what this means. What it's saying is that in the absence of a statute by Congress, which would be constitutional their constitutional power of creating legislation, their that constitutional power. In the absence of statute making and law passing by Congress, they would be under strictly a legislative territorial jurisdiction under um, under this system in the way that it was ran from 1787 all the way through the land program, which is this territorial military system.
Okay.
Right.
Well, just
So when Congress and so if Congress enacts legislation, it could potentially move provisions of the United States Constitution into that legislation and therefore into the territory.
okay. Yeah, so it's their Article 4 state and territorial relations.
Yeah.
Boy, I'm gonna have to read that again. I'm seeing it in a whole new way.
Yeah.
All right. Well,
This
that
this was given again. I have to keep hammering this home. This isn't some book a guy wrote. This was created by the government printing office under a Senate joint resolution, I believe 69 at the time, 1952, and was written by some of the most brilliant legal minds of the time, 4 members of Congress. Okay. All right. So that kind of gives us a bird's eye view of what Congress thinks even now, even now, about the federal land issue. This is what they think of it.
wow. Well, then it's going to be hard to argue with Congress then, especially since they would appear to know more than we do, at least at this juncture. So, wow. Well, that's a great document there. I'm hoping maybe you could share that with me. You'd said something about sending me some stuff, so I'm hoping that you can include that and
I
maybe I
can do
can.
that. I can make sure you get this. I've clipped a lot of this stuff out of the books that were really important. Okay, so that this whole thing, and I can get you the other stuff too, but this
Good.
whole thing gets us sort of into um, the the discussion in the next chapter about the military system.
Right.
I'm gonna
Okay.
unshare that.
Well, I'm thinking maybe we should have we should create a storage place for all this stuff so people can grab that stuff when they want it.
Sure,
That
absolutely.
yeah, that'd be amazing. Um, cool. Well, that was really good.
Well, if I send all this stuff to you, can it go in a file
Yep.
and attach? I don't know how to do that with.
Yeah.
I'm not going to send everybody
It might cost
individually this stuff.
it might cost some money depending on how big the overall file is. And I have to check if it's access only or if they can download it. I just don't want somebody to be able to have access to the file and then remove the files and then
Sure,
have them gone. If they want to take copies of them, that would be great. So I'll have to see what
right.
that looks like. But that would be actually really amazing. And we can actually put the folders in there according to the video, maybe, if we have time to do that. So that would be pretty awesome. Um, well, that now that we understand exactly what we were talking about the federal lands and concurrent and exclusive jurisdiction, uh, now it's time for a nap. Oh my gosh, it's something. Once
The
you look
funny
at
thing is, like you were saying before, it's like we haven't even gotten into
uh,
the later portions of the book, and it's already 6 videos in, and it's highly information dense.
right,
It's because I spent a lot of time going through and trying to find all this documentation so that I could tell this narrative, and it was disparate and all over the place, and I had to glue and tape and to create this narrative, and it was crazy, but it sort of leads to the next thing, and so I mean, does that segue us into the next chapter? Where are we at in the book?
no, heck no, we just we're only 3 pages. No, I'm kidding. So I'm gonna go through some highlights in here, and then if you feel like you need to jump in, do that, okay? Because that's the
Yeah,
whole point
okay,
of me trying to do that. So I had written on the side that my wife's calling. That the state's sovereign power is dependent upon the percentage of federal land ownership. That leads to the nullification aspect for people. And it's really interesting. It would be interesting to communicate with some of these people from the 10th Amendment Center to be able to see how they operate, because a lot of them will say, oh, well, the nullification has been used thousands of times. And it would be really interesting to be able to see, okay, well, if it has, then it would cause us to question, what is the general understanding that people have? And maybe maybe you don't, but if the general understanding through the what is it, the Virginia and Kentucky resolutions, is that the states have the authority to be able to nullify anything that is an abuse of federal power on their hand. That sounds really great. That sounds very Confederate, that right? uh, rather than than
Right.
anything else. But then you have this understanding that you have, and it actually gives us one could say it gives us a worse position, because now it gives us less of a leg to stand on. So
Right.
where are people? I mean, where do you have people like the 10th Amendment Center and and even the John Birch Society? They're like, oh yeah, we have the ability to nullify, but nobody's really, that I know, has even talked about this issue. So can you speak to that at all? Or is
Yeah,
it just
sure.
okay?
So the thing about exercising power is you have to, the state and the federal government have to know where they're exercising power, right? So let me ask you just a simple question. You can work this out simply. Everybody listening to this. Can the state exercise power on federal land if the federal government is applying exclusive power to it?
No, not at all.
Okay, so now we need to figure out how much of the state of Idaho can the state of how much of the state of Idaho can the state of Idaho apply its 10th Amendment power to?
The amount of state-owned land, or
That's
that's
right.
not under exclusive jurisdiction.
Right. Well, so we would have to try to figure out how much is concurrent, and whether or not the federal government believes that it's concurrent. It's like, from our experience, the federal government is operating in on its territories, its properties now. They were territorial, now they're properties, but they're operating on their properties as if they're exercising exclusive power.
Well, so then couldn't we did a video on the Texas border, for example. Wouldn't the same situation apply? I mean, we were talking about, okay, we have a border, right? Everybody thinks everything that is north of the border belongs to the United States, but nobody ever thinks about who has jurisdiction over that. Well, is it in
Right.
Texas in this particular shape? Well, it might be, but there's a 50-mile buffer zone. Whose jurisdiction is that? If the federal government is there and the states want to truly, occupy their jurisdiction on their land, the feds could just say, okay, go ahead. Later, we'll pack up our stuff and we'll leave. Is that the same type of principle that we're talking about?
Yeah,
Okay.
yeah. So the state of Texas, for example, because it's got this huge problem on its hands, it has to try to get into a conversation with the federal government involving the court to try to ascertain who has rights, jurisdiction, this sort of thing on the 100-mile or 50-mile border zone, right?
Mm.
They've got to have that conversation. And until the state forces it, the federal government's not going to take it up. The federal government is never going to approach the state and say, well, let's talk about, you know, us exercising our exclusive power here. Maybe it's not a
Because
good idea.
it's already assumed, right? It's already
You have to
assumed.
understand, we have to assume that the United States federal administrative apparatus is always, always, always going to seek some way to apply exclusive power. Why? Because if it does, it doesn't have to worry about the state or the citizens stopping them from getting their agenda done.
And when the states are in a vassal state arrangement, they're not going to challenge the superior, right?
That's right. That's right.
Oh man. Oh, that's okay. So, let's see. The feds won't. Let's see. I wrote that the feds won't acknowledge concurrent jurisdiction, which the lands would be disposed. Land patents. Does the
But
Constitution
I'm
also
about to
apply?
explain to you
Okay.
why the states in the United States have adopted a stand back, and let's not let's not try to take on the United States government too much or point out things. We'll just kind of go with the flow. I'm going to tell you why here in a moment.
Okay. That's good. Do you want to jump into that now? Because the next part is
I gotta do a screen share.
okay.
So let's just bring it up. Okay, I bet you can see that just fine.
I can.
Okay, I gotta explain this. Let's just go down here and I'll explain it. That clip is from the book The Right of Territories to Become States, written in 1892. The writer, Edmund Steele Joy, was a Union commander in the Civil War. The book, as it states as the opening pages, partially fulfilled for Edmund the requirement of Doctor of Philosophy in the University Faculty of Political Science in Columbia College. And as I say, Columbia College will become a common theme throughout the book, and it does. So let's go back up. I'm going to read this to you very slowly, like we did before. The conflict of opinion regarding the nature of the American Union was settled by the Civil War. What does that mean?
Well, that means that rather than the fight between the North and the South, one being the Union side and the other one being the Confederate side, the idea is that since the North won, that the Confederacy side died, and we're all under a union.
Yeah. So many held before that time that the nation was a result of a compact. Do you know what the compact was?
No.
The compact was the League of Friendship.
Oh, the Articles of Confederation. Okay.
No,
What? That's not
the
it?
League of Perpetual Friendship was the Confederacy.
Oh.
It was an agreement between the states. It was just a Confederate agreement. The Articles of Confederation were drafted for the Confederacy. The United States Constitution was drafted for the Confederacy. The Confederacy was a separate deal. It was an agreement of League of Friendship between the states. That was the compact.
So did the Articles of Confederation come because of that? Or is that easy to
Yes,
say? Okay.
yes, yes. The compact was the League of Friendship between the states. That was a confederacy. That was the compact. That was the agreement. That confederacy created the Articles of Confederate Government and the Constitution.
Okay. That's good to know.
So let's read this again. Many held before that time that the nation was a result of a compact entered into by free and independent states, which, while recognizing the Constitution as a common bond of union, yet left to each state as a part of an inherent sovereignty the right to either nullify a national obligation or withdraw without the of national influence and power. Everything that you just talked about is addressed right here. What was the outcome? This conception of the Union, which is known as the state rights doctrine, was adopted by the Southern states, and their deliberate acts of secession were immediate cause of the Civil War and all its attending disasters.
Written just like a unionist.
Do you understand what this is saying?
Yes. Was it just what I said or not? The
Here, I'll just read the
the
rest of it
fact
and
that
then
the
we'll
result
discuss
of
it.
the war actually determined whether we were going to be a union or we were going to be a confederacy.
That's right.
Right.
But with the defeat of the South, the dogma of states' rights perished. Well, there was no states' rights doctrine. All it was a confederacy, a league, a compact. What does this say? The defeat of the South dissolved the Confederacy, and we moved from a confederacy to a union, which is a vassal state arrangement. Henceforth, the Constitution is to be viewed not as a compact, a confederacy, a league of friendship between the states, but as the fundamental law of the whole land, a military um, dictatorship, basically, a very light form of a military dictatorship. As the expression of the will of the entire nation, and arguments relating to it must be based upon that fundamental conception. This right here is the law of the land right now.
Where did his thought become? Where did this come out of? What is this?
I let's one more time. The right of
It was
territories
out
to
of
be
his book.
states,
So if it's out of
written
his
by
book,
1892, written in 1892 by Edmund Still Joy, who was a commander in the Civil War.
well, what made him the authority on whether something perished or it didn't?
He's not telling you that he did this. He's telling you that this is what he was being told. This is what the thing, this is
Oh, I
how it
got it.
went
Okay.
down.
Okay. Got
This
it.
was the Norse. Okay, so this goes hand in hand with the governor of Florida's admission. What was the governor of Florida's admission? Well, let's just read it. This is a Perks copy. Sorry, Caleb, I'm using your copy, buddy. This is what he said to, this is what the governor of Florida said to a meeting of the legislature as soon as they got word of what was going to happen with their status from Congress while they were under military occupation. He addressed him. He said, I am glad to be able to say that no part of the blame of this violation of what we understood to be the pledged faith of the nation is imputable to the president, meaning that the president doesn't agree with what's he's about to say here and what's about to happen. He's not in agreement with. You understand what I'm saying?
Yep.
Okay. So far as the president, is concerned, he has endeavored to comply with our reasonable expectations. By his proclamation of August 20th, he declared the insurrection at an end, the cessation of martial law, and a full restoration of our civil rights. What civil rights? Their civil rights, meaning their membership in the Confederacy. But a powerful party has arisen, which declares that he had no right to make that proclamation and that his act is therefore void. It is also due to the president to acknowledge that he has done all he could to secure our right of representation. But unfortunately, the dominant party are fearful that the admission of the Southern members might transfer the balance of power from themselves to their opponents.
So
Hence,
were we
hence,
Republicans?
they
Okay, sorry.
deny the constitutional right of the members from the 10 states. That is the membership in the Confederacy that he's talking about right
Yep.
there. Go ahead.
Yep. Yep. So are we going to say at this particular time this was the Republicans? This was
Rhinos.
under
Rhinos.
but the under the God, I'm embarrassed to say it. Was it under Lincoln?
Yes.
Huh.
Lincoln tried to stop this. As he says right there. Do we need to read that again?
I
Lincoln
don't
tried to stop this.
I don't think so. It's good to know that he tried to stop it though. I mean, he's got such a bipolar reputation, right? I mean, General
Well,
Order
people don't
100 and
know.
such, right?
They if they knew this history, they might think differently of Lincoln.
Yeah. Well, I think we look at his General Order 100 and we look at De Lorenzo's book and some of that stuff. So people either take
The
a
powerful party in Congress dissolved the Confederacy and created the Union.
isn't that interesting? Wow.
They basically made the entire United States a vassal state arrangement.
That's tough to
The southern states were under military occupation. The military report says as soon as they were considered under military occupation, they were territorial. That means they were added to the land program. That means they were going to be disposed of according to the land program. What was the land program at this time? It was a vassal state program.
Okay. So I'm confused because I was aware of the disposal program fell under two categories, at least two primary ones. It was the Ohio territories, which was created by an enabling act, I suppose, under the Northwest Ordinance. Is that right?
Yes.
Okay, so then there is another disposal program.
No, remember when we talked about this? There was no legislation for the new vassal state program.
Okay.
None. There is none. There's never. I've looked for 14 years to try to find legislation, enabling legislation for the government's program from the Louisiana purchases onward. There is none. I can't find any.
Wow. Well, at least all the Americans that are watching this video will understand that the property rights are not guaranteed in areas that are unincorporated. So, um, and knowing that our president actually tried to stop this, which is a good thing, but it ended up going forth anyway because of the dominant party. So one could say if the dominant party, if history repeats itself and the dominant party remained in control, then the only way to be able to unseat this, do you think,
They're
would
still
be
in control, Tom.
well, that's my point, is that
Okay.
they're still operating this way. So if it was done by the political party, the only way that it could be unseated is either by an acknowledgement or uh a recension maybe from the party or from the other party. I mean, if
What?
if the party were to change dominant parties and we ended up, let's say, having the Democrats in control and they knew this, would both the Republican Party and the Democrat Party, they could both turn this. What's our remedy, I guess, is what I'm saying. I mean, is
That's
this
already happening.
okay?
Let me help you out. Why do you think President Donald Trump has been under siege?
Because he's pissing off all the right people.
No, because he created a faction that is getting rid of this system.
Oh, that's right. Good.
The MAGA faction is breaking with the powerful party that had risen.
So do you think they know this?
Yes, they do.
Well, then that's
Donald
sort of
Trump doesn't know it,
right.
but the people that he's breaking with that have had control of the system since the Civil War, oh,
Right.
yeah, they know it.
Okay.
That's why this is the viciousness with which they're going after him. It's coming from right here. Right here.
And the Republic and the dominant party doesn't like him. Isn't that ironic?
Yep.
That's unbelievable to me. That's unbelievable to me. Wow. What a revelation. Revelations. Okay. So should we go on a little bit?
No,
We got 4
I,
minutes. We got 4 minutes up to an hour
I
already.
think people are probably trying to fit me for a noose about right now. I don't know.
Well, I think they're just trying to figure out how to, swallow a porcupine. It's just, they know they got to eat it because they're hungry, but it's going to be murder trying to get through those pines. So,
Oh,
anyway, well, we do only have 4 minutes. Do you want to just finish up with some blah, 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 and then we can pick up
well,
with the next
I got one
series?
more exhibit. Or maybe I don't,
Okay.
maybe I've done them all.
No,
Yeah, that's pretty much the exhibits for today. And I knew this would be, there's a lot more to discuss. We could spend a lot of time on this. There's a lot of information in the book. We're just not going to be able to cover it all. That shows you step by step how all this transpired. But this is probably the greasiest part of the book. It's just hard to. Do you have any questions on any of this stuff? I know it's hard, but
I don't know. I have questions, I actually put page numbers. So I'll have to, let's see, we're on page. We jumped like 2 pages today. So so basically let's see, I don't want to read them because I wrote these. Okay, I'm just going to ask these anyway because these might be common questions that people would ask, okay?
yeah,
You stated that the Northwest Ordinance was passed by a constitutional government in 1789 and slavery was abolished in the territories. Can the is the New World Order? Sorry. There's my conspiratorial hat. NWO, and for
oh,
all intents and
Northwest
purposes,
Ordinance,
it's
New World
Northwest
Order.
Ordinance. Was it still in force after the passage of the Constitution? And wasn't slavery abolished by the Constitution, not by the Northwest Ordinance?
Yeah, so slavery in the Constitution only applied to where the Constitution went. So if the Constitution follows the flag or doesn't follow the flag, right? So we got to have that conversation again. Did the Constitution follow the flag into the territories? No. Could they then abolish slavery in the territories? Look at the congressional debate between Calhoun and Webster. It this is what they were talking about. Calhoun was like, um, if the Constitution follows the flag into the territories, which is what he was for, is he thought, well, then we would have the constitutional right to have slaves. And Webster was going, well, first of all, no, the Constitution doesn't go into the territories. And so they, out of the conversation between the two of them, they agreed that, okay, there are certain provisions of the Constitution that would be applicable to the territories. They never say which ones. They just say that, right? Because there, this was all nascent. These conversations were nascent,
Wow.
meaning that they were just organic. They were just coming up. They were just, this is the first time that they were really figuring this out, whether or not the intention of Congress was that the Constitution would be operative in the territories to frustrate the land program. So this nascent conversation between these two senators is of vital importance to understand, and I have a section of it in the book. You can get a if you get the military reports. That conversation is like there's pages and pages of that conversation in those reports because when we took military possession of Puerto Rico, the commander of the military, Elihu Root, he wanted to know, all right, we got possession of these insular areas. What is our constitutional duty here? Well, so the compilation of the reports was to try to give Elihu Root some level of understanding of what we had done domestically already and
So
apply it to Puerto Rico.
So maybe a good question, now that you mentioned that in a different way, is, we've discussed what might not be guaranteed, right? The private rights might not be extended, under federal, exclusive jurisdiction. So in these in the areas where the federal government is exercising exclusive jurisdiction, what are their what's the documentation? What's their boundaries?
So
So
I'm going to say something really quick. There's going to be wingnuts out there that are going to watch these videos and say, he's saying that private rights don't apply on federal property. I'm like, that's not what's being asserted here. So for the wing that are going to try to make this into something that it's not, I'm telling you what the literature says. Go back to the earlier in the video where we showed that clip that came out of the Constitutional Encyclopedia. The way that the court, the federal court of the United States in the Downs versus Bidwell case handled this matter was they called it a guarantee of private rights, meaning that the government could or could not, and it was a political decision
Well, the wingnuts can simply
purely.
go, they can scroll back to the video a little bit and they can look
They need to.
at the source documents that you just mentioned. I
They
mean,
need to.
it's pretty hard to argue with, if what you're saying came right out of the Constitutional Encyclopedia and it was authorized by Congress, it would be a little difficult to argue with that.
Well,
At least with an opinion.
well, there's some wingnuts on Reddit that just, they don't
That's
like to read apparently. So
No, but we're running into the world that pretty much doesn't, and so it's kind of funny, I guess, when as we talk about it, is that one of the reasons why these videos are being done is because we know that there are people that are not going to read. There aren't going to, this is some really, really complex information, and you really either have to be a crazy person to read it, or you have to have a genuine desire to be able to want to understand, the problems that we're dealing with, understanding history, understanding the political side of this, and understanding the legal side of what was going on.
right,
And some people will, the other sad part is that people I think might end up watching these videos as a shortcut, which I strongly do not recommend, because this is to be more of an accompaniment to
right,
those that actually read it. This might give you a general overview of what's happening, and we're trying to be as detailed as possible without making 9,000 videos, I think. But it's meant to be as an accompaniment, and maybe that should be a disclaimer: is that don't look at this like these are the words that like the discussion what we're saying is going to trump the book, because the book, I think, at least in my opinion, is much more superior than at least anything that's going to come out of my mouth. All I'm just trying to do is to be able to
Same here.
help people take the complicated subject matter that we're talking about that comes out of your head, and I'm kind of like the sieve to kind of like make it easy for us simpletons. So
Well, I appreciate that, Tom. And this has been it's taken a long time to assemble all this information, write in the book. I had to write the book 5 different times because, excuse me, the data is difficult to put into a cogent, seamless, easy to read narrative, right? Because
right,
it's very complicated.
yeah,
Um, there's going to be people that are going to look at some of what we talked about here with the Civil War and this sort of thing, and the states, the southern states being territorial. They got to read the reports to see that,
yeah,
right? So if you read the reports and you go, oh, they're being held as territories, then you'll automatically go, well, if they're being held as territories, what program would that be under? Well, there was only one, and that's the PI program. So then
right.
the question would be, well, were the southern states then added to the pie for redistribution?
That's a good
Basically, yeah.
question. That's a good question. Well, I think we're gonna finish there. We're at 3:04, so we're slightly over an hour. Ron, thank you, man. I really appreciate it. Hopefully you guys benefit from this video, and if you do, continue to follow us. Check back with his playlist, subscribe to the YouTube or the Rumble channel or wherever else this is going, and share it with other people. We've got to understand we have to understand our history. We have to understand how we got here, and I have found no better way to know that than to be able to understand the history of federal lands in the United States and violence of faction. So if you're interested in a book, or you're interested in contacting Ron, if you are in a place where you want an interview, any sort of media inquiries, it might be good for you to be able to click on the contact tab on his website. And again, the link will be in the comment box. We're encouraging you to buy the book and then follow our videos as an accompaniment to what you learn. And we're hoping that we will eventually become a well-known resource for a lot of people, as the relevance of what he talks about seems to uh, seems to be all over the media. So anyway, Ron, thank you this afternoon. I look forward to seeing you after my vacation.
Well, thanks,
And
Tom, for having me. And dude, I hope you have an amazing vacation, you and the wife, and
yeah, it'll be great.
drink lots of Mai Tais.
Yeah, it'll be really good. Yeah, we won't talk about that in the air. But anyway, all right. So until next time, everybody, thanks a lot.
All right, thanks.